Alright, we can also agree to discharge the contract by agreeing to discharge. Alright, discharge by rescission. Rescission is a process by which a contract is canceled or terminated and both parties are returned to their positions they occupied prior to the contract. Alright, so again, let's use He-Man and Cute Fuzzy Bunny. Okay? They enter into a contract for the purchase and sale of widgets. He-Man says, hey, I'll sell you 1,000 widgets. Cute Fuzzy Bunny says, okay, I'll give you $1,000. Alright, for whatever reason, things go south. They agree to discharge the contract, to rescind the contract, meaning that He-Man gets his widgets back, Cute Fuzzy Bunny gets their $1,000 back. They just agreed, okay? Mutual rescission is both parties must make another agreement. I agree to give you back your money. I agree to give you back your widgets. It also satisfies the legal requirements of a contract. It's just another contract, folks. They're both agreeing to rescind the contract. Discharge by novation is another good one. Novation is both parties agree to substitute a third party for one of the original parties. It has certain elements. Generally, you're going to see this in corporations. You have an incorporator, a person who tries to start a corporation. Well, before the corporation is actually started, they have to enter into a contract for, like, a lease agreement of some sort. But requirements for novation: a previous valid obligation, meaning that this incorporator entered into a valid contract for the lease purposes of the building for the corporation that doesn't exist yet. An agreement by all parties to a new contract, meaning that everyone has to agree to a new contract. The extinguishment of the old obligation, namely the incorporator being liable under the lease, and a new contract that is valid between the corporation and the landlord. Okay, that's all it is. Discharge by substitute agreement. It's a compromise or settlement agreement. Folks, believe it or not, you deal with car accidents. You start litigation with the insurance company. You are allowed to settle those disagreements, meaning that, hey, for X number of dollars, we agreed not to sue. Right? That's just a substituted agreement. Discharge by accord and satisfaction. Do not try this with your bills. An accord is a contract to perform some act to satisfy an existing contractual duty. Satisfaction is performance of the accord agreement. So basically, this is where you have some sort of a dispute with, like, a contractor, and you owe them X number of dollars for work they've done. Well, you don't think it's worth that, so you write them a check for 10% less, and you write on the check accord and satisfaction. If they cash it, it is acceptance of that new contract, and you are no longer liable for that 10%. But folks, that gets very hairy. I do not recommend that. Discharge by operation of law. Alteration of a contract. An innocent party may be discharged when the other party has materially altered the written contract without consent. All right, so we got Manny Faces here, okay, and he's a real monster. In case you didn't know, you see that? No, you can't. Anyway, he has a green face, and he unilaterally does something to change the contract. Okay. Now, the innocent party, who's clearly Peter Veckman right here, may be discharged when the other party has materially altered the written contract without consent, meaning he's off the hook. All right. Also, we have the statute of limitations. You probably heard about this one. Restrict the amount of time in which a party can sue on a particular cause of action. So, meaning you only have X number of years where you can sue someone on a particular cause of action. After that, it's discharged. Bankruptcy. Discharge in bankruptcy will ordinarily bar enforcement of most of the debtor's contracts to their creditors. All right, this is why bankruptcy is very popular right now, because it discharges debt that the person in bankruptcy owes to their creditors. All right, impossibility and impracticability of performance. Impossibility of performance is superseding events such as a fire may make performance impossible in an objective sense. So certainly, if I enter into a contract to buy, your grain, and it catches on fire, well, obviously, you can't perform under the contract anymore because the grain's been destroyed. Now keep in mind that's just regular common law. You know, when in doubt, read the contract to see what it actually says about such events. Objective impossibility of performance. Objective would mean that's like a reasonable person. It cannot be done, whereas subjective would be the individual's thoughts, meaning the individual say, I'm sorry, it can't be done. Grounds for the discharge of contractual obligations based on impossibility of performance. When one of the parties to a personal contract dies or becomes incapacitated prior to the performance. 2, when the specific subject matter of the contract is destroyed. Or 3, when a change in law renders performance illegal. So certainly all of these would discharge contractual obligations. All right, what about temporary impossibility on the other hand? This is an occurrence of events that makes performance temporarily impossible, operates to suspend performance until impossibility ceases. So this does not destroy the contract, it merely just puts on hold for a while. Commercial impracticability. When a supervening event does not render performance objectively impossible, but does make it much more difficult or expensive to perform, the courts may excuse the party's obligations under the contract, and that's a big may. Frustration of purpose is a contract will be discharged if supervening circumstances make it impossible to attain the purpose both parties had in mind when making the contract.